Hi everyone, my name is OPT Lawyer, and I'm going to answer the question you have in your mind right now. Yes, this is a different shirt with the same cartoon otter on it. His name's Lutra, and he's a character I play in a tabletop RPG called the Bay City Chronicles. If you're interested in that for some odd reason, I'll put a link down in the description. But this is drawn by a very good friend of mine. His name is Chammy. He draws really cute things. So I'm going to put a link to his art in the description below too, because, he's cute. Anyway, I want to talk about arraignments, because that seems to be one of the things that people don't quite understand about the criminal justice system. And okay, to be fair, a lot of you probably do understand it, but I read social media comments, probably a mistake. So let's start with this. Let's say news media stories come out. Person X has been horribly murdered. Person X was loved by his family, by the community. He's a community figure. And he is dead. And the news media says that defendant is a suspect in the crime. In the shooting of Person X. And then defendant is arrested. And then defendant is indicted by a jury, or grand jury. And then he shows up in court for arraignment. What is arraignment? Arraignment is simply when the court tells you you've been indicted by a grand jury of murder, or whatever. And it is, now it's time to enter your plea. Now, we've all seen this on, like, Law & Order, right? So, what happens at arraignment? I plead not guilty. Well, okay. Most of the time, it's actually your attorney entering a not guilty plea on your behalf. If you have an attorney, in felony court, 99.5% of the time, a judge is not going to accept a guilty plea if you don't have an attorney of some kind. If you have an attorney and he's not there, judge won't let you do that, again, most of the time. Even if your attorney is there, it's arraignment. Most of the time, you're not going to plead guilty at arraignment unless you already have a deal worked out with the state. And why? Well, felonies are kind of a big deal. Like, even, like, your low felonies, kind of a big thing. They can harm your future forever. So, we want to make sure you have an idea of what's going on first, and we want to make sure that, the state can at least meet its burden to, one, get you to plead guilty, or plead guilty to something else, or two, take the thing to trial and prove you're guilty beyond a reasonable doubt. And yet, I see a lot of people, when a defendant, in the example, would plead not guilty, would type in social media, But he did it! Why isn't he admitting it? How could he plead not guilty? Well, okay. Again, number one, you were basing that off of things you've seen in the media. More than likely. I know sometimes I see actual witnesses, like, putting things on social media about it, but, little tip, probably shouldn't do that, because sometimes those words can come back and haunt you. But, number two, sometimes, and this is between you and me, sometimes the news media doesn't get it right. Also, say hi to my cat. It's shocking, right? I know. Sometimes the news media doesn't quite understand what everything is, or doesn't quite get the facts right. Hey there. Hi, this is Tina. She's cute. Anyway, social media is just a bevan of people who either don't understand or don't care. And that's kind of the big problem, right? Most of the time, they act like we should just shoot the defendant. We should just shoot the defendant in the middle of the courtroom. Obviously, we can't do that. Number one, he hasn't been proven guilty yet. Number two, we don't shoot people in the middle of the courtroom. Sorry. Doesn't happen that way. But, what is the purpose of the arraignment? Again, it's to notify the defendant that he's been charged with something. It's to set depending on the court you're in, set a schedule as to we want discovery done by this time. Pre-trial will be set here. Maybe set a trial date. If it's like a murder case, they don't tend to set trial dates that quickly. Again, depending on the court, but a lot of times in a case that's clearly going to take a bit, they're going to set pre-trials and try to move discovery along at a good enough clip that the case just doesn't sit there doing nothing for a while. But pleading not guilty, all that does is it puts into dispute the elements of the crime. That's it. It is the defense saying that the state, we are holding the state to its burden of proof beyond a reasonable doubt as to each and every element of the crime. What's an element of the crime? Well, let's take theft. Theft is the knowingly taking of property or services from somebody without privilege to do so, with the intent of depriving the owner of said property or services. So, for example, let's take this. Let's say that this was on a desk of a colleague of mine. And let's say at the end of work Friday, I decided to just take this off of his desk. And now I have it here. And I'm basically intending on keeping it because I took it. That would be theft. Shocking, right? But let's say it went to trial, and let's say the state was unable to prove that I didn't have permission to take this. The without privilege to do so basically means I did not have permission to take this. Let's say the state can't prove I didn't have permission to take this. Now, there's a lot of reasons why you can imply such a thing, but if the victim doesn't come in and say anything at all about it, and, there's no inference whatsoever that I wasn't just allowed to take this home, I'm not going to be able to be found guilty of theft. Now, again, there's a lot of reasons you can imply such a thing. Again, for instance, if this is, embossed with this person's name, that would be kind of a hard thing to say, oh yeah, he let me have it without, any proof of that whatsoever. But again, it's on the state to prove it. It's not me to prove the opposite. All arraignment is the start of the process. I really can't stand it when I see people on social media, going crazy because somebody pled not guilty to something. That doesn't mean anything. Again, no judge is going to take a guilty plea just at arraignment without, a deal or an attorney or something there, without a very long discussion with the defendant as to why are you pleading guilty at arraignment. It's not really heard of all that often, again, without a plea deal already in place. And again, we want to make sure the state has the right evidence, because let's go back to this example here. Let's say that the owner of this thermos, whatever, claims that this is worth $5,000. I don't know, maybe he thinks this is ruby or whatever, I don't know, but let's just pretend that he claims this is $5,000. And let's say, for some odd reason, he's got proof that this is worth $5,000. Well, me taking this would then be a higher felony of theft. It'd be a felony level theft. In fact, it'd be probably a higher felony level theft. But let's say we go to trial, and let's say that instead of being able to prove that this is worth $5,000, let's say the state is only able to prove that this is actually only worth $15. That kind of drops the case down from a higher felony to a misdemeanor. We call that petty theft here. That's part of the reason why you plead not guilty at trial, arraignment, because that kind of thing happens a lot. Not to this extreme, kind of a silly example, but a lot of times the defendant is charged with something and ends up pleading to something lesser because a lot of the time that's actually closer to what happened. So, for instance, a murder case. Well, maybe it wasn't the purposeful killing of somebody. Maybe it was an accident. Maybe it's what we call involuntary manslaughter. Or maybe it's voluntary manslaughter because maybe it was provoked by the victim. Now, again, we don't excuse that for the most part. I'm not saying self-defense, saying that, say the victim somehow provoked the defendant into attacking him, and in doing so, the defendant kills him. And let's say that provocation is sufficient for a jury to say, hey, you know what? It's not murder, but it's voluntary manslaughter. Again, these things happen. They do. And you wouldn't have been able to show that if you just walked in and pled guilty at arraignment. We have this system in place for a reason. It, one, protects, it does protect the accused. And I know that's going to cause a lot of problems with some people. But what about the victims? Trust me, I know. Victims are great people. I like them. I love them. But they have the state, and the state has unlimited resources for the most part. The defense has their attorney, and if they have money, then okay, great. They can bring experts in and whatnot. If they don't, well, then we have to ask the court to give us money for things. And, you know, that's not the easiest thing in the world to get sometimes. But the defense has the presumption of innocence. Innocent until proven guilty. It's kind of a main thing. Just because we want the state to show us our evidence doesn't mean that we are, you know, saying that the client or the defense is even saying that, you know what, we're not saying he's not guilty of everything. What we are saying is that maybe he's not guilty of this. And after discovery, maybe the attorney determines, oh, yeah, they kind of got you. That's happened to me a lot. I've had clients who are charged with theft of stealing stuff from a Walmart, and they told me, well, I wasn't there, and then I show them a picture of them there, walking out of the store with the merchandise, and not like an overhead camera, like that face level camera, like you just get the shot, like he's like, you might as well just be looking at the camera doing this, and then they look at me, they're like, oh, okay, yeah, I was there. That happens too. Arraignment's just the start of the process, guys. It's not the be-all, end-all. And somebody pleading not guilty at arraignment shouldn't cause a big backlash. And yet I see it on social media all the time. Social media is where I like to go to find these misconceptions of the criminal justice system. I might be something of a masochist. It does hurt my soul a lot. But, you know, that is going to be what it is. But, again, the main distinction is pleading not guilty, again, doesn't sit there and say, I didn't do it. It's, I'm saying the prosecutor can't prove its case beyond a reasonable doubt. Now, maybe that is, I didn't do it to a lot of people. But let's take, y'all remember the Duke lacrosse case from, like, 2006? That's the one where the Duke lacrosse players were charged with, sexual assaults against other people, and after a lot of things happened, the Attorney General of the state of North Carolina came out and dropped all the charges and declared the players to be innocent. Normally when a state dismisses a case, it does so for reasons of we can't prove the case, or we have evidentiary concerns, or we're just deciding not to bother. My state uses the phrase noli prosequi for that because Latin is cool, I guess. The point is, when a prosecutor comes out and declares a party to be innocent, they're not saying that we couldn't prove our case beyond a reasonable doubt. They are saying this person didn't do it. You may think, well, that's not a big distinction. It kind of is. Innocent until proven guilty, right? So if you're not guilty, then you're innocent in the eyes of the law, yes. But if you want to get technically speaking, a not guilty finding by a jury simply means that the state failed to prove its case beyond a reasonable doubt. A jury doesn't find you innocent. It's not guilty or innocent. It's guilty or not guilty. But that's the end of the trial. We're talking about arraignment. And really, that's all I have to say on the matter. Like, when you see news stories about things, I just ask, you know, take a lot of things you see in the media with just a grain of salt. Just a little one. And again, it's entirely possible they're going to get it right. It's entirely possible the person who is charged with killing person X is going to end up entering a plea to it at some point. Let the process work. I know it takes a while, and, but we want immediate justice now. Well, this isn't Law and Order. And we want to make sure we have the right... The state wants to make sure it has the right person, for crying out loud. Like, the state's burden of proof to indict somebody is probable cause. That is a very low standard. Like, it's kind of the opposite of beyond a reasonable doubt. Here. The state wants to make sure that they've got the right person. Because the last thing they want to do, like straight up, prosecutors will tell you this. The last thing they want to do is convict somebody who didn't do it. And then number one, now they have an innocent person in prison. Number two, now they have to actually go find the person who did it. And try arguing to a jury that this is the person that committed the crime when they can sit there and say, yeah, but that person was already convicted of this crime. It's not that hard to argue around, but it's one of those things that, well, okay, that's an interesting story, state. Hope you can actually prove your case. So, yes, at the end of the day, all arraignment is the start of the process. It will always be the start of the process. It will never not be the start of the process. And yes, on rare occasions, it can be also the end of the process. And this is felony court, because a lot of times, like in your misdemeanor cases and whatnot, it's like traffic cases, traffic violations, arraignment, pretty much you walk in and most of the time you plead no contest to the ticket. Because why? It's a traffic ticket. Some of those you don't have to show up for, but most of the time you show up, you enter a no contest plea, the judge gives you a fine, maybe court costs, maybe nothing, maybe you get points on your license, and then you're on your way and no one cares. Misdemeanor, like your petty theft, whatnot, even then, most of the time you'll plead not guilty at arraignment, but, sometimes, like, depending on how busy the court is, like with the misdemeanor court, sometimes you walk in, you'll just talk to the prosecutor, they'll be like, okay, here's the police reports, and, I'll drop this down to unauthorized use of property, and, recommend 6 months probation. The defense attorney will take that to their client, and they'll walk in and just plead to the amended complaint, and you're done. That's it. Felonies? You're not going to get that too often, because those are way more important. Felonies can hurt you, financially, not because of financial penalties, but, you're going to lose the ability to get a number of jobs. You now have to, put on every single job application that asks that you have been convicted of a felony. You can't get certain jobs. It's a major hindrance to your life. And yes, if you did a crime, then I'm sorry, you deserve that. But if you didn't do a felony, getting back to this example, if you didn't do a felony, if you only did a misdemeanor, well, that's something we should discover before you enter a plea to a felony. Just saying. So, I don't know if this has explained anything to anybody. Like, anybody watching this may have already known all of this, but I hope to at least get somebody, like one person out there, that the next time they see something in the news media, they don't immediately believe it. Like, I'm not saying you shouldn't always believe it. I'm just saying that, you know what? Let's wait for the process to finish. Or at least let's wait for the process to get rolling a bit. Because the last thing we want to do is basically spam how horrible this person is all over the place, only to have them be found not guilty at trial because maybe the state didn't actually have the evidence to convict him. And now a person who is innocent in the eyes of the law now has media about him all over the place saying, but he's guilty. Try explaining that to somebody you're trying to get an interview with. But I was like, the jury found me not guilty. See, I've got the order right here. I was discharged. And like, yeah, but if we hire you, we've got like this group of 700 people here that don't like you. I don't know if we can deal with that. That is what it is, but whatever. But again, if I can get one person to at least look at a news story sometime and just not go crazy when the defendant pleads not guilty at arraignment, then I would be happy. That's all. Thank you for watching, everybody. Comments, critiques, complaints, whatever, please leave a comment. Also leave a comment for any potential issues you'd like me to talk about. I want to focus on misconceptions on the criminal justice system. I do not want to talk about like actual stories. Like I want to talk more general. But if you have anything at all you'd like to know anything about, just say so, please. Thank you. Thank you guys all for watching. I appreciate it. Bye.